Hello, everybody. Welcome. We have convened this meeting to talk about the press clause of the First Amendment. I'm Floyd Abrams. We will all be speaking here to you today. I thought I would just start by going back to the very beginning of the Constitution drafting. One of the first things that James Madison said as he got up in what is now Federal Hall in New York for the first Congress, new country. So one of the first things that he outlined and said to the first Congress related to the drafting of, and he had done a draft of what became the Bill of Rights. And I wanted to start by reading to you Madison's one line, first proposal, quote, "The people shall not be deprived or abridged of their right to speak, to write, or to publish their sentiments, and the freedom of the press, as one of the great bulwarks of liberty, shall be inviolable." That word inviolable found its way into a number of state constitutions of the day and is still in a number of state constitutions. But that was the way Madison wanted, or himself at least, had first drafted it. And of course, there was editing, and they spent a lot of time editing. The idea of having a Bill of Rights was itself controversial at the Constitutional Convention. And in Philadelphia, the first vote on it was unanimously against it, 10 states to 0. 3 people hadn't arrived yet in Philadelphia. But there was support from the start of having a written Bill of Rights as part of the Constitution, even though that first vote was, as I said. And when it came to Constitution drafting, there came to be a lot more support for having a Bill of Rights. And that paragraph that I just read to you from Madison was his first public articulation in July 1787 of what the First Amendment should relate to and protect. Looking at American constitutional law, there has not been much use made of the concept of the press requiring or receiving some sort of special protection. There are a lot of important cases, to say the least, that the press has won, and in which freedom of the press was referred to. 2 of them that I've been involved with. One was the Pentagon Papers case, where, efforts to enjoin publication by the New York Times of this then secret study of how we became embroiled in the war in Vietnam. And in the arguments, occasionally there was reference to the fact that this was the press, and that the press needed, the public was served by specifying that the press should receive, whatever it meant, special or articulated in any event, rights because of the role that the press had played, and because the press had, of course, often been suppressed in the days leading to the revolution. So we had that, and after all the drafting was done, we had a clause in the First Amendment, which unfortunately starts with the word "or." Not the strongest way to rush into court about the "or" part of the First Amendment. But there it is, freedom of speech, deprivation not allowed, or of the press is the language. And it's language that to a great extent has been all but forgotten. And it's that led us, especially people here with me, to think that we might write a serious article about the press clause, what we call the forgotten press clause of the First Amendment. In part, this came as a result of conversations that Senator Barron and I had through the years about that. This wasn't much press clause law, press at once in big cases, but there wasn't, nobody was really saying, what about the press clause? And so, with a lot of work from a lot of people, two of whom are sitting next to me, we came out with a 93-page document called the Forgotten Press Clause. And that is the background to our meeting here today. It is obviously speculative, it has to be, in terms of judging or trying to look to the future in terms of how things would be different if we had a more invigorating, alive press clause. In part, that's for the attractive reason that, of course, the press has won some very important cases. And that in those cases, the role of the press was very often center stage. So in one case, we deviated completely from English law with respect to the protections of the press. Justice Black and Justice Frankfurter had a great debate in their opinions, in a case in which the Los Angeles Times had urged, insisted that a judge send someone who had done bad things to the jute, that's what the word, jute, to the jute mill. So direct advocacy by the press that your sentence ought to be jail and work, held to be contempt of court by the California Supreme Court on the ground that this was an effort to influence a judge in assessing what sort of penalty should be imposed. And with English law as background, it was perfectly clear then, 1941, as it is now. That language of that sort, Judge, you ought to send that guy to jail, would be contempt of court. And here, with that case, it's not, and it is protected speech. And the Pentagon Papers case, I was involved in 1971, top secret documents during a war, a study commissioned by Secretary of Defense McNamara of how we got into the war in Vietnam, and in a sense, what we might do to get out of it. Every page, 7,000 pages, classified, every page stamped, top secret, sensitive, in the midst of a war, and the government went to court and sought a prior restraint on the New York Times for publishing any more, and lost. 6-3, but lost. I don't think anybody doubts that in England, in Canada, in other great freedom-loving countries, we would have lost that case with respect to that sort of material published during the war. In fact, I've often thought if this had been World War II and a similar document had been prepared at the request of the Secretary of War, that the press would have lost that, given the fact that it was a bigger war. Everyone was involved, and the government had gone to court back then and said these are top secret documents. Don't tell us they don't amount to a whole lot. Don't tell us they're historical things that were said in the Pentagon Papers. In the middle of a war, the government tells us that these documents are not just classified, but that they would be significant harm to the country if this were published. In my own sense, thinking about this a lot, 2 years after the Pentagon Papers case, I was surprised that that case could have been lost. In fact, I don't think the New York Times would have published the sort of study that the Pentagon Papers case was about during World War II. So in any event, we have a body of law now which is rather protective of the press. I would say in general, quite protective as against other democratic, freedom caring about countries. And sorry to talk about my cases, but in another case, the Press Association case, an issue came up which has been long decided in English courts and would still be decided in English courts in a different way than occurred in that case. Criminal defendant confesses. The press has the confession. The press publishes the confession. Basic fact to the case. And the question is, what is this allowed? It's not allowed. It's a contempt of court in lots of democratic countries around the world. And we argued successfully that the press had obtained it lawfully. That wasn't part of the problem in the case. That there were other ways to assure a defendant a fair trial than suppressing the press when it wrote about it. And most of all, that the dangers of prior restraints on the press were so great that even in this situation, where at least the issue was whether a defendant's rights to a fair trial would be impaired. That the First Amendment prevented. So what more does our team want? Why are we here today talking about the press clause and at least inferentially, what rights does the press not have? What additional rights or powers might accrue to it if the law were to be changed in one way or another? And what makes what I will call constitutional sense in terms of the application of language always sitting there but rarely quoted by the Supreme Court, separately identifying the press as entitled to First Amendment protection. The only commercial entity mentioned in the Bill of Rights at all is the press. Only the press and religion are the only sort of outside of government matters even contained in the Constitution. We search in vain for language in the Constitution, including the Bill of Rights, for language about not how many years as a president served or Congress or this or that, but about an outside entity, and it's only religion and the press. So we're here today to discuss a document, or prompted by a document that we wrote, that Sandy and I had talked about for years, writing something about the press clause, that my colleagues on my left will ask to speak next, toiled mightily on and worked for years in the drafting of this document. We were all involved in it, but there's a difference between people who edit and people who do research. And these guys are ones who did work. It's fun to edit, but work. So I'm going to call on each of them, and I'm going to ask them to describe who they are and what they think of in terms of the potential meaning of, the consequences of a reinvigorated press clause of the sort that we have never had. So on my left.
Hi, I'm Isaac Barnes-May. I'm a recent graduate of this law school in 2024. Before that, I got a PhD in history, or American Religious History at the University of Virginia. This actually doesn't have much to do with American religious history, but it is the other part of the First Amendment. So I was really drawn to thinking about the historical aspects of this argument. So when we're thinking about what an empowered press clause does, our report looked at sort of a number of different ways that it has a tangible effect in the world. And we really broke this up into a number of different buckets. We thought about one, access issues, thinking about the ability of reporters to get access to sources. This could be things like freedom of information, but it also includes aspects of, for instance, you've got a press pool, right? There are a limited number of reporters that can be part of the press pool to go into the White House press briefing room. Who gets access to that space and what kind of restrictions can you put in place on that? Is there a right under the press clause for certain organizations or individuals to have access to a press pool? What is it? We talked about news gathering conduct. A lot of the discussion on this actually focused on the question of thinking about protests. So if you have protests right now, reporters are subject to generally applicable laws regarding criminal conduct. You've got a protest in a park, right? You've got a reporter who happens to be in the park. If they're arresting protesters and clearing out that park, the reporter can be arrested along with everyone else? Are there any kind of special protections that the press has that prevent them from being arrested? We talked about thinking about editorial autonomy, right? What rights do people have when they put together a paper or put together some kind of news publication? One of the questions here is also, is there some kind of protection from government going in to search about how people made those editorial decisions or went into the publication? Does being the press have any kind of inherent preventing of someone from going through discovery to figure out every single decision that a paper made? We talked about publication. This is probably the easiest one and the one that few people disagree with. People right now would generally say that probably if the press clause does nothing else, it prevents what's called title restraint. The government can't say that you can't publish something specifically, although this still comes up often in the national security context especially. And then we also thought a bit about thinking about the economic viability of the press. Right now the press, particularly local news, is under extreme amounts of pressure. It's rapidly closing down in many places or consolidating. And so one of the questions is, does looking at the press clause as part of the Constitution offer any kind of path to something that would support the press? Perhaps there's an exemption to monopoly practices to allow the press to consolidate to get a better negotiating position for social media. Perhaps there's some form of subsidy that would be involved in having the press in the Constitution. And one other thing that I think is also worth thinking about is, as we were talking about this, and this project is going into the next year thinking about ways to implement these ideas, are also changes in terms of freedom of the press. So one thing we've been especially worried about are changes in libel law, as well as potentially thinking about the ways that cases like New York Times versus Sullivan, which really has been so influential in preventing the press from being sued for libel, could potentially change in the future. And so one of the ways that we think about the press clause is, if worse comes to worse, the press is endangered by a legal regime that ends up really harming the media in various kinds of ways, is the press clause something that could be used as a defensive posture, sort of a way to fight back against various forms of government regulation, against various kinds of legal changes that would put the press in an even more precarious spot?
Well, thank you, Jacob. Anything left to say, or have we exhausted?
We've done pretty good.
Oh, why don't you speak in?
Mike?
Yeah, if I can get closer to you.
See if I can get it out of here. Everyone hear me? No? No? All right, I'm just gonna project. Okay, so I don't have much else to say.
Why don't you say, I really should have introduced everybody,
Sure.
but what you've been doing now professionally in your life.
I'm Jacob Schreiner-Briggs. I'm a 2021 graduate of this law school, currently a visiting assistant professor at Chicago-Kent College of Law, and then in between graduating Yale and being in my current job, I was the first Isaac, so I was a resident fellow of the Yale ISD. And I spent 2 years working on these issues and helping write this report. So I'm excited to, with this group, share this work with all of you. I think maybe to zoom out a second, so the threshold problem that we were dealing with constitutionally was the Supreme Court has essentially read the press clause out of the First Amendment. So press cases, traditional press cases, even in the middle of the 20th century, were ultimately decided on speech clause grounds, even if there was a lot of rhetoric in those cases about the importance of the press as an institution. In deciding those line of cases, the Supreme Court built out a speech clause doctrine. So now we have this other language in the First Amendment that is sitting on the shelf, collecting dust. Okay, so that's like the conceptual constitutional problem we're dealing with. I would also suggest, though, that this constitutional problem has real immediate, real world stakes because the press matters and because the press is in trouble. So the press matters institutionally because the press, properly conceived, is a knowledge institution that acts consistent with certain norms of knowledge production and dissemination. And that practice, that work of that knowledge institution is important for democracy. At least the limited conception of democracy has informed self-government. It's not the only conception of democracy, but it's an important one. So the press matters. And the press is in trouble. The press is in trouble in many dimensions. First and foremost, local journalism is dying. The business model has collapsed. And so we see this slow but steady erasure of local news outlets and original local reporting. That's not good for a lot of reasons we could get into. More major and financially stable news organizations, just plucking from recent headlines, increasingly willing to settle defamation lawsuits with the Trump administration, perhaps for reasons because the Trump administration or any presidential administration currently has leverage over the institutional press in ways that it shouldn't, and maybe in ways that an invigorated press clause could help with. And third and finally, and we won't get too deep into this, but I think the institutional press is suffering from a trust problem. A lot of major institutions right now are suffering from trust problems. The Constitution probably can't solve all of these problems, but I think it could get at some of them in a few ways. So let's just talk about local journalism first. One of the things we talk about briefly in the report is that an invigorated press clause might serve as constitutional justification or minimally constitutional defense of targeted subsidies from Congress at local journalism outlets. That's one possibility. And so it helps the economic problem because local journalism is a public good. It needs public funding to work economically. So that's one thing. With regard to leverage that government has, the executive branch has over journalism, I mean, we could look at a couple things. Maybe the press clause helps with access rights. So you're dependent less on the goodwill of the sovereign to get the information you need to report, right? And so therefore, the administration has less leverage over the press. Or maybe you see strength in defamation protection so that these lawsuits get dismissed quickly and immediately, so that news organizations are not pressured to settle, right? So that's a possibility. And then as for trust here, all I'll say about this is we currently have a press clause that isn't being used. I think if we did, we would have to have a change not just in the way the First Amendment gets interpreted, but we would actually be relying on a shift in constitutional culture more generally. If the court suddenly decides, hey, the press clause does matter, John Roberts reads our report and he's like, wow, that makes some great arguments. And now we have a line of decision saying, no, the press clause means something and it protects this institution or people who are the press. That would signal a significant shift in our constitutional culture. And I think that has knock-on effects too, because in this country, we live under a system of constitutionalism that has very serious cultural implications. And if you had a constitutional culture that respected the press as an important democratic institution, maybe that would help, would not solve, but maybe would help. The idea that the press, like all actors, all speakers on social media, no one is to be trusted. Maybe we'd start to chip away at that. I'll stop there. Thank you.
Well, thank you. Jack,
Well, everything's been covered.
I understand.
Did you want to ask me anything in
I
particular?
did.
All right, fine. I didn't work on this report. So I didn't work on this
I
report.
know. And I'm a little concerned about the next question. I feel obliged to ask. How shall I put it? Have you read it?
Yes,
Good.
it's the one they were working on.
Yeah, I know.
I would tell them things,
I
and they
know.
would ignore what I said, and
Yeah.
then they would just do the next draft.
My question is, how to put it, is this a real problem? I don't mean the omission where, the court could have done this or could have done that. Have we a press problem in the country of the sort that we ought to look hard to see how we can reinvigorate or make the press more protected than it is now, particularly in a world in which fewer and fewer people get their news from anything we would have called the press just a few years ago.
Okay, so there is things that you could get out of a reinvigorated press clause. Most of them have to do with questions of access and reporter's privilege. And also, you might be able, as a shield, to get, or rather as a way of justifying certain kind of funding programs for the local players. Think about, you have a problem under the First Amendment, Minneapolis Star, Arkansas Lawyers Project versus Raglan, which makes selective subsidies to the press problematic. And if you wanted to do a system of public subsidies for the press, you'd have to get around these precedents, and here the press clause might be useful as a way of saying, no, this isn't a problem, in fact, if anything. The government has implicit obligations to do so. So these are the areas in which the press clause can do the most work. But the problem of the press is much larger than the set of issues that we could deal with through a reinvigorated press clause, which is, you should understand, is not a claim that we should not try. It's just that the problem is larger. Jacob already mentioned several of them. But one way of putting them all together is to think about the demagogue's playbook. So what's the demagogue's playbook? This is, by the way, under the hypothetical that someday the United States would be under the leadership of a demagogue. Now, I know this could never happen, but suppose for a moment that it did, all right? So in that unlikely set of circumstances, there's a pretty standard playbook that a demagogue would use to undermine the press. And not undermine it in the sense of getting rid of it, but basically turn it into a caged or tame animal, which is easily controlled, right, and subservient. So the demagogue's playbook consists, the first stage is to go around and say, as much as possible, that the press is a disgusting, lying enemy of the people. Again, I'm making this up, so no one would ever say this, but imagine that somebody did. So what you just do every day, 24 hours a day, is you use the organs of the press against themselves by basically telling everyone how distrusted press is and how it shouldn't be trusted, how reporters are all criminals, how the people who run it are are corrupt, and basically no one should trust anything. It's the first thing you do. The second thing you would do if you were a demagogue is you would nurture a set of counter institutions, which are basically mouthpieces of the regime, and basically never say anything bad about you, and engage in all sorts of Orwellian groupthink and newthink in order to basically put the best possible face on all of your activities. So that's the second thing you would do in the demagogue's playbook. And the third thing you would do in the demagogue's playbook is you would find ways to staff the regulators of the press with your cronies. That is, people who will do your bidding and will find different ways to use the regulatory apparatus of the state to put pressure on the institutions of the press so as to make them docile. See? And the fourth thing you would do is to find points of leverage. So for example, if it would turn out to be the case, again, this is a hypothetical example, suppose that in fact major institutions of the press are owned by very large corporations. And these corporations in turn have interests unrelated to a free press. For example, they might want to, merge with other corporations, and they might want to do various things that would increase the value of their shares.
You're just spitballing.
What's that?
You're just spitballing.
I'm just making this up. I mean, it's amazing, science fiction. And what you could then do is you could leverage their interest in profits for their shareholders to basically make them docile, so that they wouldn't demand all of the rights that this report argues they should have. Right? So you argue for all of these rights, and then it turns out the institutions that are beneficiaries of these rights willingly surrender them because they want extra goodies for shareholders. So these are the elements of a demagogue's playbook, and they actually have happened in different ways in places like Hungary, right? Thank goodness. Nothing like that is happening in the United States. But if it were to happen, you can see that the press clause would only be one small part of the strategies you'd have to use. Now, one thing you might think about in combating the demagogue's playbook is to find ways to create many different sources of news coverage so that it's impossible to co-opt them all, and impossible to crush them all, and impossible to put them all under heel. And this, you should understand, is the second best strategy. The first best strategy is that the people in power wouldn't dare to try to do this. But the second best strategy in a world where they're determined to do this is to find alternatives that can in fact gain reputations for being reliable and trustworthy, and finding ways to insulate them from the attacks that are inevitably going to happen. One way to do that, by the way, we've already mentioned. It's procedural rules within litigation to make it easier to beat back attempts to try to silence press operations through expensive litigation, and in some cases ruinous litigation. Another way is to decentralize the sources of funding for the press. So one problem is that if all of the funding is coming from one source, and that source is captured by people who basically want to turn the press into a docile animal, then in fact this creates even greater leverage than almost anything else I mentioned, right? So as you're thinking about systems for subsidizing the press, making it possible for news organizations to hire full-time reporters, making it possible for local journalism to thrive, making it possible to defeat the inevitable forms of corruption that develop when you just don't have any reporter in the state capitol or at the city council. When you're thinking about those particular kinds of subsidies, think of them in terms of decentralization structures so that they're not also easily captured. Now, it's true that any such system of decentralization, of funding and support, can inevitably be used in ways you think are counter to the purposes of the press. So any such system will fund and subsidize somebody that you think really shouldn't be subsidized and is doing things that you think are not in the public interest. But the point of decentralization is not to achieve perfection, it's trying to achieve insurance. And insurance is a kind of spreading of risk so that the worst doesn't happen. And now in a world in which we were facing the demagogue's playbook, this is what I think we would have to do. Multiply the number of different voices that can contribute to the creation of the news. Find ways to gain trust among the public, and find decentralized ways, perhaps through the tax code or other ways, of subsidizing these voices. And then basically ride out the storm.
I'm glad we solved that problem.
But it didn't happen, so I don't have to worry about it.
Well, let me give a current example which has been adverted to hypothetically and non-hypothetically, but which it's very much on my mind. Jack adverted to the settlements of certain cases. The one that really sort of drives me crazy is what looks like it is going to be a vast settlement with the new owner of CBS, which is Paramount, to hypothetically President Trump, who has sued with an extraordinary theory that CBS, by its editing and the like, made his opponent for the presidency look better than she should have. That their editing process of putting this there and that there was loaded in her favor to make her say things she didn't even say because it sounded better. By all accounts, from people who have compared what the vice president said and what CBS showed her saying, it was a perfectly fair, journalistically defensible effort by CBS, limited time, very extensive text and the like from her. But one of the things that sort of drives me crazy about it is, what is this lawsuit? What, the opponent, even put aside the winning opponent, the opponent is suing the broadcaster on the grounds it just wasn't fair. They made her look too good. They saved her from being criticized. So that's the claim. And people are talking about a $30 million settlement. There have been other settlements recently, also, in my view, outrageous in their amounts with ABC. But this is the one that really gets to me, because I don't think a candidate has a cause of action against a broadcaster, newscaster, or the like, who made her look better than she should have looked or seemed. But that is where we are, and to be sure, a press clause expansion cannot solve that, and cannot even begin to solve it. What it can solve is legal problems. It can make it easier. It can afford greater protection beyond what would otherwise have been the case. It can allow the press to be places that it wants to be, from which it is now excluded. When there's a riot, when the other untoward activities are going on, the press wants to be there to report about it. Even, and there have been such cases, a big fire in a city. Firemen go, questions arise, will they let the press in? Now, I don't think there ought to be any sort of absolute right for the press to do that, but the reality is that historically, at least in New York City, the police have let the press in, and the police have required a press card. And that has resulted in litigation, because the question is, who gets to be an accredited, so to speak, journalist? Who gets the press card? And there was a litigation about that. It was settled. It seems to be working out. But back to sort of why we're here, it's fascinating to me that, and cheering in a not so cheering world on subjects such as this, that there are situations in which entities can really sit down and work out issues such as who can be there, how obstreperous would it be? To what extent would it interfere with the police, fire, etc.? And one of the problems, I suppose, with an overbroad definition of who is the press is that that type of situation, can someone attend or not, in a situation in which there's not really room for everybody that would like to be there, and in which beyond that, police lack the institutional capacity to what, interview everybody that wants to attend. It doesn't work. The easy way to deal with that is no one can be there. And that is an unacceptable and problematic result. Back to you guys. If there were sort of one thing that, you would really be cheered by, smile, please. You'd really be cheered if we started down a little more legal protection for the press. Where would you like the press to be, or in what circumstances protected in a manner that does not currently exist?
Yeah, so I mean, Floyd, I think you spoke to the access cases, but just to give sort of a concrete example, during the first Trump administration, there was the case of Jim Acosta, who had his press pass revoked. And CNN sues, and they were eventually able to get it back on the basis of a due process claim. The way that they had revoked the press pass didn't go through the proper due process, that there weren't the right procedures involved. And one could imagine a world in which if the administration had maybe been more careful in how they revoked the press pass, that you could have just revoked the press pass without CNN actually being able to take any action to restore it. If you saw the press clause as having some kind of inherent meaning about the ability of news organizations and reporters to function as proxies for the public, to be able to speak about to the public about what a presidential administration was doing, you could imagine that there might be some kind of grounding in the press clause for the argument that a reporter having the ability to report inherently has a virtue, that the executive branch needs to allow reporters to report, particularly if they represent large numbers of people in their reporting. And there might have been an additional reason to allow Acosta to keep his press pass. And so I think cases like this will keep coming up. The other sort of example that keeps coming up and has come up throughout the various workshops that we've convened talking about the press clause is the threat of the government going into a newsroom to look for classified documents. That news organizations regularly report on the things the government does. Sometimes this involves them being in possession of documents which involve classification. They're classified at various levels. The government can even classify documents that are already public, so they can retroactively classify documents. And so one of the real concerns that various journalists have expressed is the idea that the government would go in and start searching everything in a newsroom, all of the reporters' correspondence, everything involved, looking for classified documents. And as of right now, there's no sort of immunity that news has over that kind of search. There's no special protection that journalists would have in having the classified documents. And if you had a presidential administration that was interested in pursuing that kind of action, there's just not a defense against it. And I do think that one of the real appeals for looking at something like this, trying to empower the press clause, is that it uses something grounded in history, something that comes from the framers, feel like maybe there's some kind of hedge against that kind of action.
Okay.
Yeah, I'll just zoom out one more time. I'll be brief. So I think for me, what an invigorated press clause would signal would be, again, a change in constitutional culture. If the press clause is different, the culture is different around what the Constitution means and what its implications are. An analogy that through the workshops I was a part of that came up was the Second Amendment context. So in 2008, you have a case, District of Columbia v. Heller. Court says Second Amendment gives you an individual right to self-defense. That had not been the case for decades, including prior Supreme Court interpretations of the Second Amendment. So some scholars say that they looked at Heller and they said, well, this is popular constitutionalism. The reason we have this case now decades later is because you had this movement dispersed throughout civil society to push for this reading of the Second Amendment, right? I'm glossing over details, but in a world where we have a press clause that recognizes the independent value of the institutional press, then presumably, or at least possibly, we've had a corresponding shift in culture, where people have recognized, not just the court, but people have recognized the value, the institutional value of an independent press. And I think that gets you a lot. There's the formal legal protections that matter, but then there's the more broad-based consideration for what democracy requires and what types of information we want to have at our disposal when we attempt to self-govern. And in a moment that feels kind of bleak, I hold on to hope that the demagogue's playbook is met with some type of response, and maybe that's through a shift in constitutional culture.
Any of you have any questions or observations? Yes.
I don't necessarily believe this, and I'm not a First Amendment scholar, but you come here to get pushed, so let me push you a little bit. In the hypothetical that Jack was talking about, the most decentralized option is that everybody with one of these who has social media can report the news. I realize there's logistical problems with that, like who would get to come to a police situation, maybe by lottery or something like that. But that is decentralized. It is very difficult to capture something like that. If that were the case, then it's hard for me to see why speech should get less protection than the press. I guess that's my question. Why should press get, whatever press means, which is a slippery concept anyway, why should that get some kind of protection that speech doesn't if we can all report the news?
One example that I think was really interesting that came up in a lot of our discussions was the example of how the press is treated versus how religion is treated. So, for example, Virginia right now has a law that attorneys can access court records. And they can do this, they can go to a database, they're allowed access to this court record system. And right now, nobody else can do that. And so attorneys here are treated in a special way, right? They're a special class of people, but the press isn't. So if you're a journalist and you want to report on stuff, you don't have access to that court record system. Now, if you end up with sort of a similar scenario with religion, say you've got an exemption for a law that exists for certain classifications of people, the Supreme Court has said that if you're a religious group, you always get included in that exemption. The First Amendment means that you are treated so special that you will always be included in there. So there's a case about a bunch of, there are Muslim police officers, there's a law, or rather the department regulation says you can't grow a beard except for health reasons, but you can if there's a religious reason. We always treat religion most favorably. We don't treat media in the same way, and this has some real implications for access. Another case about this is Media Freedom and Information Access Clinic did a case at Yale that was specifically thinking about whether people could fly drones in Texas. In Texas did a statute, it had, I believe, 35 separate exemptions for various people. You could fly a drone if you were a real estate developer. You could if you were engaged in academia. You could fly a drone if you were doing sports broadcasting. You could fly a drone if you were inspecting an oil pipeline. No exemption for journalists because journalists just weren't seen as important in that way. And this has real implications for the ability to do basic reporting on various things. And so I think in questions like this of how you're treating journalism versus other kinds of people, you need some kind of heightened protection for people engaged in reporting the news. You need some kind of special way for people to get access at least as favorably as other groups. And there are real implications if you don't.
I should say, though, that that's not entirely responsive to Ronald's question. Because Ronald's question was, let's suppose that you have an action scene, you have a Defense Department briefing.
Yeah.
And the question there is not letting drone operators in, but not reporters. The idea is that there are thousands of reporters, each of them has a cell phone. What could possibly justify allowing cell phone owner one in and not the NBC affiliate in? So that's a different question, and it requires a different kind of answer, because we don't say, well, the Protestants get more rights because they're a larger denomination than the Catholics. We just don't do that, and the Seventh-day Adventists are out of luck. So you have to do a different argument. So the argument's got to look something like this. All right? Don't worry. Let me make the argument. So when you think about coverage of stories, access to the Pentagon briefings, or I'm about to fall off the ledge. This is what happens to the press, it falls off the ledge. Access to Pentagon briefings or coverage of disasters, things like that. The role that the institutional press plays is different because, in some sense, it's representative, but it's not representative in the sense of an electoral representative. So in other words, think about different notions of representation. One notion of representation is similarity. I'm similar to you, I represent you. Another notion of representation is democratic, which is I elected you, so you represent me. A third notion of representation, however, is based on expertise or professional identity. So in other words, when you think about debates over healthcare, for example, most people obviously want safe things. They want the food safety, like that. But in fact, the people who actually spend time focusing on questions of medical care and health safety, these represent the interests of the public. But the reason they represent the interests of the public is not they were elected. Often they aren't. They're often self-appointed. It's because they've devoted the time and attention and they have the expertise to basically ask the questions that need to be asked. So if you wanted to justify any kind of access model, which basically focuses on institutional press, more than just the guy with a cell phone camera, it's got to be based on some theory of democratic expertise. That is to say, in a democracy, you have to have representatives of the public, but the representatives, given the scarcity, are the people who basically spend their entire professional lives gathering facts and reporting them to the public. Now, that's not the religion model, it's a different model, but what did you want to say?
No, I mean, I think that you can justify access in, for instance, like the corporate context. You've got a fixed number of seats through the press acting as a proxy for the public. There are questions about how to do that, right? Whether there should be some kind of professionalism required to do that, but you could also do that by audience share, right? If you're going like, we've got this trial, we've got a select number of seats, you can go, CNN has a large percentage of people that watch them, millions and millions of people. And this then becomes a question if you've got other news sources or other forms of information distribution that reach similar numbers of people. But I do think audience share is, for instance, one of the easier ways to determine that an organization or person is acting as a proxy for.
Well, you know, it's funny, this is a great alternative to conceptions of representation. I gave a professionalism account and he gave an audience share account. These are both accounts of representation. Right now, the new Secretary of Defense has decided that he doesn't want CNN and these various other folks represented at the press briefings. He wants the Epoch Times, right? And I take it, you know, maybe if Joe Rogan asks, maybe Joe Rogan can send a representative. And from the standpoint of audience share, well, maybe. In other words, maybe it turns out that more people listen to Joe Rogan now than read the New York Times. Probably they do. So if we go by an audience share model, then the Defense Department's justification would be, you know, there's nothing you can say about it. It would just be the right thing to do. So it's obvious that we have to have some combination, and this is exactly how it usually is done, some combination of audience share models and some combination of professional, reputable institution models, and it's often done through a sort of secret sauce that isn't made entirely transparent.
We've got a bunch of factors in the report thinking.
Exactly.
You know, one thing we have to bear in mind is with the changes in technology, working these things out doesn't necessarily become more difficult, but very different in kind than it has previously been in our history. It frustrates me that I cannot read about the Super Bowl in the New York Times on the Monday after the Sunday. Not a word except read us online, and tomorrow we're gonna have all sorts of, Tuesday, we're gonna have all this stuff here, you know, for you laggards, you know.
Is this the dead tree New York Times or the online New York Times?
No, this is the print, as we call it.
The dead tree New York Times.
Yeah, and I watched a golf tournament on television. I had to leave my house. I didn't know who won.
You didn't miss anything, Mike. I'm a Chiefs fan, and I'm telling you this. You didn't miss anything.
And it wasn't there. It wasn't there the next day. It was also, you know, go online, our online, you know, we'll tell you. But I mean, and so that's just therapy for me, that I can tell you this. But it does suggest that as the technology changes, anything we do, Constitution aside, but including also, as Jack's example point out, have to take account of where do people get this information from? Because it may be a lot, you could argue, less necessary for journalists to be here and there, and there, if there's a camera and everything comes out and you can just watch it, except for those of us who don't. So, yes, please.
Professor Bulkin, you mentioned that something that you would want to consider when looking at different news organizations is sort of institutional legitimacy. What would your criteria be for that?
You mean institutional legitimacy in terms of access?
Yes.
Is it a professional shop? Do they have, do they hire journalists full time? Are they devoted to, is that what they do? What's the kind of institution they have? There are some institutions that, and you might want a mix of institutions. You might want institutions that represent broadcast media. You might even want podcasters, because podcasters can also develop certain kinds of expertise as well. So it's not about the particular medium, whether it's broadcast or something. It's about the question of, what do they do? Let me put it this way. Think about it this way. Anybody with a cell phone camera can go to a city council meeting. I'm not sure they'll let you record the city council meeting on a cell phone camera, but anybody can go. The question is, who will actually write up what happened at the city council meeting? Who will write up and analyze and explain to you what went on and what possible skullduggery might be hidden in the seemingly innocent exchanges between the different members of the city council? Well, there are two kinds of people who might do that. One person is basically a person who doesn't have a life. This is what they do, right? And the other person is a person who basically, this is their profession. Their life is this, and they do that as well. And there's room for both of these people, but for the vast majority of folks, they're not gonna do it. They're neither people who lack a life, nor are there people for whom this is their life.
Since I've got you here, and since a letter to the editor in the New York Times by me has literally been published online.
You got published in the New York Times?
As we sat here today.
Isaac's been published on Facebook.
I would like to read my final paragraph, dealing again with these super settlements and the millions of dollars. I wrote, it is not easy, not inexpensive, and surely not without risk for publishers to spend years battling any president, let alone one who has a history of referring to journalists as enemies of the people. But it is not too much for the public to ask of the press that it remain vigilant in its coverage of him and militant in defense of itself. Now you know.
Okay. Well, because it was in the New York Times,
Yes,
you have to believe it.
it must be so. Right. This is Dorothy of Santa Claus. Right. Okay, thank you, everybody. It's good to meet you all. I wish you all well.